Hi, welcome to Ashford University, course HCA 322, week 2, discussion 2, case number 3. Good evening, Your Honor, ladies and gentlemen of the jury, and representative of AU Hospital. My name is Nancy Phoebus, and I am the representative of the plaintiff, Jennifer, in the case of Jennifer versus AU Hospital for impermissible uses and disclosure. AU Hospital is a public hospital in response to a subpoena not accompanied by a court order, impermissibly disclosed the protected health information, PHI, of one of its patients, my client, Jennifer. Contrary to the privacy rule protection for information sought for administrative or judicial proceedings, the hospital failed to determine that reasonable efforts have been made to ensure that the individual whose PHI was being sought received notice of the request or failed to receive satisfactory assurance that the party seeking the information made reasonable efforts to secure a qualified protected order. I am here to prove that AU Hospital failed in providing ample information to my client and receiving from her permission to release such records. The Health Insurance Portability and Accountability Act, known as HIPAA, became law in 1996. In April 14 of 2003, was the compliance date for all covered entities. These covered entities include healthcare providers, health plans, healthcare clearinghouses, and other having access to patients' protected health information, PHI, in oral, written, electronic, or other format. PHI is any individuality identifiable health information relating to a person's past, present, or future health condition, provision of health care, and payment for that care. It includes any personal identifiers such as name, social security number, address, medical record numbers, and telephone numbers. The healthcare provider must be diligent in exercising and fulfilling HIPAA requirements. This is for their patients' protection as well as their own personal and service providers' protection. Failure to comply with HIPAA privacy law can result in civil or criminal penalties. Each covered entity service provider must have an appointed chief privacy officer responsible for developing and implementing policies and procedures and assuring compliance with all HIPAA regulations. As I was preparing for this case, I came across a few articles that are very pertinent and I'd like to share with you. If your records are subpoenaed for a legal proceeding, ask the court to open only a specific portion of your record or keep it closed. After the case is decided, you can also ask the judge to seal your medical information. If the request for my client's medical records was subpoenaed for a legal proceeding, ladies and gentlemen of the jury, wouldn't my client know about such requests? I have the answer to that. General information, physician, and other healthcare providers often receive subpoenas directing them to produce medical records and to testify regarding patients' care they provided. It is important that practitioners know the purpose of a subpoena and their duties and rights in responding to one, as well as their legal obligation to protect the confidentiality of patients' medical records. Despite the official appearance and legal language of a subpoena, a prudent healthcare practitioner will not assume that a subpoena is valid and must be honored without questions. Releasing a patient's medical records in response to a subpoena that is not accompanied by signed authorization from the patient may place a practitioner in legal and professional jeopardy. I have a scenario here of a case that went to court, the matter of Crescenco versus Crane in the state of New Jersey, in which the appellate court ruled that physicians can be legally liable for disclosing medical records in response to an improper subpoena without the patient's consent and knowledge. In conclusion, the HIPAA has 4 paths in protected health information, the PHI, and it starts as follows. Obtaining the PHI from providers, judicial or administrative order, subpoena or discovered request for qualified protective order, subpoena or discovery request with notice requirements, medical records, and authorization, they all must have the patient's consent. Ladies and gentlemen of the jury, I ask you, please find the defendants guilty and please grant my client, Miss Jennifer, to win this case against AU Hospital in failure to provide protection to my client, their patient. Thank you.